Special day, and this evening it's very special because of the fact that we are organizing this Justice Dr. M. Rama Joyce Memorial 6th online lecture series in commemoration of 95th birth anniversary of Justice Dr. M. Rama Joyce sir. And these lectures are being organized annually. ಸೊ ಪ್ರತಿ ವರ್ಷ ಈ ಜ್ಞಾಪಕಾರ್ಥವಾಗಿ ಈ ಉಪನ್ಯಾಸಗಳು ನಡೀತಾ ಬಂದಿದೆ. ಬಹಳ ಒಂದು ಅದ್ಭುತವಾದಂತ ಒಂದು ಕೆಲಸ ನಡೆಸ್ಕೊಂಡು ಬಂದಿದೆ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಟ್ರಸ್ಟ್. ಸೊ ಐ ಡೀಮ್ ಇಟ್ ಅ ಪ್ರಿವಿಲೇಜ್ ಟು ವೆಲ್ಕಮ್ ದ ಆಗಸ್ಟ್ ಗ್ಯಾದರಿಂಗ್. First and foremost, I welcome the president of today's function, who is presiding this particular special online lecture series in commemoration of 95th birth anniversary of Honorable Justice Rama Joyce sir. So that is Professor Prahalad R. Joshi sir, Honorable Vice Chancellor Kumar Bhaskar Verma, Sanskrit and Ancient Studies University, Assam. Sir, I welcome you to this particular lecture. And Namaste, sir. And I also extend a warm and cordial welcome to the resource person of today's session and the chief speaker, Shri S.R. Suryanarayan Rao sir, Advocate Chikbalapura sir. Tamge bahala ಹೃದಯಪೂರ್ವಕವಾದ ಒಂದು ಸ್ವಾಗತ sir. At the same time, I also welcome Professor Bhattu Satyanarayana sir in his absentia, Honorable Vice Chancellor of Central University of Karnataka, Kalburgi. Same time, I also welcome Honorable Vice Chancellor of Karnataka State Law University, Professor C. Basavaraju sir in his absentia. And I also welcome today's guest of honor, Shri Vasudev Sedamster, a trustee of Vignaneshwara Pratishtana Trust and a former chairman of Economics Department, Kalburgi University. ಇವರು ಲೇಖಕರು, ಸಾಹಿತಿಗಳು ಹೌದು ಸರ್. ತಮಗೂ ಹೃದಯಪೂರ್ವಕವಾದಂತ ಸ್ವಾಗತ ಸರ್. ಹಾಗೆ another important person who is also a backbone in organizing this particular program, Madevaya Kardalli sir, a trustee of Vignaneshwara Pratishtana Trust. Sir, ತಮಿಗೂ ವೆಲ್ಕಮ್ ಸರ್. ಮತ್ತೊಬ್ರು ಟ್ರಸ್ಟಿ ಆದಂತ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ್ ಟ್ರಸ್ಟಿ ಹಾಗೂ ಒಂದು ಸಿಸ್ಟಮ್ಯಾಟಿಕಲಿ ಆರ್ಗನೈಸ್ ಮಾಡೋದ್ರಲ್ಲಿ ಅತಿ ಚೌಕಟ್ಟಾಗಿ ಚೊಕ್ಕವಾಗಿ ನಡ್ಸ್ಕೊಂಡು ಹೋಗ್ತಕ್ಕಂತ ಒಬ್ರು ನಮ್ಮ ಅಮಿತ್ ಕುಮಾರ್ ದೇಶಪಾಂಡೆ ಸರ್, ತಮಿಗೂ ಆರ್ಧದ ಸ್ವಾಗತ ಸರ್. ಹಾಗೆ ಡಾಕ್ಟರ್ ಕೆ.ಎಂ. ಕೃಷ್ಣ ಶೇಖರ್ ಶರ್ಮಾ, ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್, ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಫ್ ಲಾ, ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿ ಆಫ್ ಕರ್ನಾಟಕ, ಕಲಬುರ್ಗಿ, ತಮಿಗೂ ಸ್ವಾಗತ. ಅದೇ ರೀತಿ ನೆರೆದಿರ್ತಕ್ಕಂಥ ಎಲ್ಲ ರಿಟೈರ್ಡ್ ಹಾಗೂ ಸರ್ವಿಂಗ್ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ಸಿಗೆ a warm welcome to this particular program, and all advocates who have gathered here in this online platform. I extend a warm welcome on behalf of Vignaneshwara Pratishtana Trust, Central University Kalburgi and Karnataka State Law University Hubli, and a warm welcome to all principals of law colleges and teaching faculty from various law colleges and the students from different law colleges, as well as all participants who have attended this particular program. So I extend a very cordial and warm welcome to each one of you who are present here. And it's also my privilege to welcome and introduce today's president who will be presiding this particular lecture. That is Professor Prahalad Joshi sir, Honorable Vice Chancellor Kumar Bhaskar Verma, Sanskrit and Ancient Studies University, Assam. I just give a brief introduction of our today's president of this function, and his profile is very vast, and the chief speaker as well as the person who is presiding this particular session. But I have been assigned with 10 minutes to complete this particular welcome address. So I'll make it very brief, and I'll try to introduce our president of today's function. And he needs no introduction because already he has delivered various sessions. He has delivered lectures in various sessions in this Vignaneshwara Pratishtana Trust. Sir took birth on 23rd June 1979 in Kalburgi, and he studied traditional Sanskrit, and and his guru is Sri Vadirajacharya Agnihotri. And sir completed his BA, MA, MSc, and he also did Shiksha Shastri, that is B.Ed in Sanskrit medium, and Shiksha Acharya, M.Ed in Sanskrit medium with first rank. And sir has also completed his PhD, and he has like Professor of Education, National Sanskrit University, Tirupati, Andhra Pradesh. He has served there, and he successfully guided more than 25 research scholars who have been awarded PhD under his guidance. And sir has written various books which is of social relevance and which is of value oriented books, and he has published more than 6 books. Some of them are Adhyapak Shiksha, Bharatiya Itihas, Bharatiya Shiksha Itihas, Shiksha Pravidi, ಈ ರೀತಿ ಹಲವಾರು ಪುಸ್ತಕಗಳನ್ನು ಬರೆದಿದ್ದಾರೆ ಇವತ್ತು ಪ್ರೆಸೈಡ್ ಮಾಡ್ತಿರ್ತಕ್ಕಂಥ ಪ್ರಹ್ಲಾದ್ ಜೋಶಿ ಅವರು. ಹಾಗೇನೆ ಇವರು ತಮ್ಮ ಒಂದು ಅಕಾಡೆಮಿಕ್ ಎಕ್ಸಲೆನ್ಸ್ ಜೊತೆಗೆ he has a vast administrative experience. He has served as head, dean, director of IQAC, chairman, member of board of studies, chairman of board of studies, member of executive council, finance committee, academic council, and chairman, member coordinator of NAC peer team, member of NCTE Southern Regional Committee, member of board of management, member of finance committee. And as I said, it would be very difficult for me to welcome and give his introduction in a very short span of time. And presently, he is serving as Vice Chancellor of Kumar Bhaskar Verma Sanskrit and Ancient Studies University, Nalbari, Assam. Sir, a warm welcome to you for this particular program, sir. And I also take this opportunity to introduce our chief speaker of today's program, none other than Professor S.R. Suryanarayan Rao, sir, senior advocate. And sir is having a versatile experience in the field of legal profession. And sir has served in the legal profession for more than 55 years of practice. He's having more than 55 years of practice as an advocate, and he has a passion towards law. And whenever he makes an observation, we can feel the weight. ಆ ಮಾತಿಗೆ ಒಂದು ತೂಕ ಇರ್ತದೆ. ಅವರ ಜ್ಞಾನ ಭಂಡಾರನ ಇವತ್ತು ನಮ್ಮೊಟ್ಟಿಗೆ ಹಂಚ್ಕೊಳ್ಲಿಕ್ಕೆ ಸೂರ್ಯನಾರಾಯಣ್ ಸರ್ ಇದ್ದಾರೆ. ಸೂರ್ಯನಾರಾಯಣ್ ಸರ್ ರಾವ್ took birth on 27th January 1950. Then he completed BSc, LLB, ML. ತದನಂತರ 31 ಜುಲೈ 1971ರಲ್ಲಿ ಎನ್ರೋಲ್ಮೆಂಟ್ ಮಾಡಿ ತಮ್ಮ ವಕೀಲ ವೃತ್ತಿನ ಪ್ರಾರಂಭಿಸ್ತಾರೆ. And he is a third generation advocate and exclusively practicing on civil side. ಅವರು ಹಲವಾರು ರೀತಿಯ ಕೇಸಸ್ ನ ಹ್ಯಾಂಡಲ್ ಮಾಡಿದ್ದಾರೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆಗಿರ್ಬೋದು, ಅಪೆಲೆಟ್ ಕೇಸಸ್ ಆಗಿರ್ಬೋದು. And sir has delivered various lectures as a resource person on various aspects of civil law. And sir is having an expertise knowledge in Hindu law. ಇತ್ತೀಚೆಗೆ ಬಂದಿರತಕ್ಕಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಗಳನ್ನ ಆಧಾರವಾಗಿಟ್ಕೊಂಡು 2 ಲೇಖನಗಳನ್ನು ಪ್ರಕಟಣೆ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಬಹಳ ರೀಸೆಂಟ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು. ಹಾಗೂ he has delivered lecture at ಚಾಣಕ್ಯ ಯೂನಿವರ್ಸಿಟಿ, ಜುಡಿಷಿಯಲ್ ಅಕಾಡೆಮಿ ಹಾಗೂ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಕಂಡಕ್ಟ್ ಮಾಡಿದಂತ ಹಲವಾರು ಕಾರ್ಯಕ್ರಮಗಳಲ್ಲೂ ಇವರು ಗೌರವಾನ್ವಿತ ರಿಸೋರ್ಸ್ ಪರ್ಸನ್ ಆಗಿ ಭಾಗವಹಿಸಿರ್ತಾರೆ. And he has contributed his research articles, and he extensively studies about books, and he quotes the edition of Mulla. And sir analyzes threadbare, ಯಾವುದೇ ಒಂದು ವಿಷಯದ ಬಗ್ಗೆ ಆ ಒಂದು ಆಳಕ್ಕೆ ಇಳಿದು ಅಧ್ಯಯನ ಮಾಡಿ ಆ ಸಂಶೋಧನಾ ಪ್ರಬಂಧಗಳನ್ನ ಪ್ರಕಟಿಸಿರ್ತಾರೆ. ಅದೇ ರೀತಿ ಅವರು ವಕೀಲರ ವಾಹಿನಿಯಲ್ಲೂ ತಮ್ಮ ಲೇಖನಗಳನ್ನ ಪ್ರಕಟಿಸಿರ್ತಾರೆ. ಅಂಡ್ ಸೂರ್ಯನಾರಾಯಣ್ ಸರ್ ಅವರ ಒಂದು ಈ ಒಂದು ಲೆಕ್ಚರ್ನ ಕೇಳೋದು ನನಗೂ ಹಾಗೂ ನೆರೆದಿರ್ತಕ್ಕಂಥ ಎಲ್ಲರ ಸೌಭಾಗ್ಯ ಅಂತ ನಾನು ಭಾವಿಸ್ತಾ I have extended a welcome to all those who are present here. And Suryanarayan sir, Rao sir, ಎಲ್ಲರ ಪರವಾಗಿ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಟ್ರಸ್ಟ್, ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿ ಕಲಬುರ್ಗಿ ಹಾಗೂ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಲಾ ಯೂನಿವರ್ಸಿಟಿ ಪರವಾಗಿ ತಮಗೆ ಆಧಾರದ ಸ್ವಾಗತ ಸರ್. So with this, like,
thank you, Mr. Girish. Thank you, Mr. Girish. ಮಾತೋಳಿಯವರು ನಮ್ಮೊಟ್ಟಿಗಿದ್ದಾರೆ. ಅವ್ರ ಜೊತೆ ಇಟ್ಕೊಂಡು ಸ್ವಾಗತ. ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಧೀಶರಾದಂತಹ ಗೌರವಾನ್ವಿತ ಸಂಜೀವ್ ಕುಮಾರ್ ಅಂಚಾಟಿ ಅವರು ಮತ್ತು ಸೀನಿಯರ್ ಪ್ರೊಫೆಸರ್ ಎಂ.ಕೆ. ಮಾತೋಳಿಯವರು ಕೂಡ ನಮ್ಮ ಪ್ರೊಫೆಸರ್ ಎಂ.ಕೆ. ಮಾತೋಳಿಯವರು ಮಾತನಾಡಿದ್ದಾರೆ.
ದಯವಿಟ್ಟು ಯಾರ್ದಾದ್ರೂ ಹೆಸರು ಬಿಟ್ಟಿದ್ದಲ್ಲಿ ನಾನು ವಿನಯಪೂರ್ವಕವಾಗಿ ಕ್ಷಮೆ ಯಾಚಿಸ್ತೇನೆ.
We organizers acknowledge and also thank and welcome His Lordship Justice Hansate Sanjeev Kumar, Judge, High Court of Karnataka, academician and Professor Shri M.K. Matoli, Mr. V. Krishnan, advocate, arbitrator, and also trustee of Sadvidya Paripalana Trust, Chennai, who is doing extensive research and reading in Mithakshara in its original Sanskrit form and text. We also acknowledge the presence and welcome each and everyone who is a student here. Though in the fraternity, they are somewhere in the career. May I now take privilege to request Sri Suryanarayan Rao to deliver his lecture.
Respected President of this evening's function, Professor Prahalad R. Joshi, Professor Vasudev Sedam, members of the Vignaneshwara Pratishtana Trust, and all my friends who are online today along with me. The primary source of Hindu law is Shrutis, Smrutis, and Dharmashastras. Therefore, the basis of law is Dharmashastra and primarily the Vedas. So therefore, while trying to understand any part of law, Hindu law, prior to its codification, we have got to rely upon the works of very great rishis in this behalf. Primarily, there are two schools of Hindu law in India. The first school is the Mithakshara school. The second school is the Dayabhaga school. The Dayabhaga school is primarily confined to the West Bengal area, whereas the Mithakshara school consists of 4 different sub-schools. The first is the Banaras school, and they follow the Veera Mitrodaya and Nirnaya Sindhu as the primary rules which govern the law in Banaras. Mithila school, they follow Vivada Chintamani, Vivada Ratnakara, Madana Parijata, and Vyavahara Mayuka for the rules to be followed in Mithila school. Then the Maharashtra Bombay school, they follow Veera Mitrodaya and Nirnaya Sindhu. This is in vogue in Western India, and they follow these texts. Then the Madras school, they follow Smruti Chandrika, Parashara Madhaviya, Saraswati Vilasa, and Vyavahara Nirnaya. This is followed by the Madras school. These are primarily the law is laid down by Yagnavalkya. Yagnavalkya Smriti. Yagnavalkya is said to be the grandson of Vishwamitra. Vignaneshwara's commentaries on Yagnavalkya Smriti is popularly called as Mithakshara law. And if we should very carefully go through the Mithakshara law, the primary concept of succession in respect of property belonging to a joint family is by survivorship. And in respect of self-acquired property, the son, grandson, and the great-grandson alone are entitled to succeed to the property of a Hindu. If women have no right of succession, they have only a very limited right of maintenance from out of the estate of the joint family. The widows, the other female members of the family, they have only a right of maintenance from the assets of the joint family, and in case they are not members of a joint family and they live separately, then from their husband's estate. In Dayabaga school, there is no concept of joint family. There is no concept of joint family property. There is no question of right by birth in the assets of the joint family. And as long as a person is alive, he would be the exclusive owner of the properties, and only on his death, the property passes to his heirs. This distinction, and the most important thing in a joint family is, if a co-partner dies, the property goes by survivorship and not by succession. That was the original law. And a son born in the family always takes a right by birth in the properties of the joint family. The concept of right by birth is a special aspect of Mithakshara law. Then we will have to understand what is a joint family or what is a co-partnership. Only male members are members of the co-partnership. The wives of the co-partners and the unmarried daughters in the family, they would together constitute a joint family. A co-partnership is a joint family is a larger concept. Co-partnership is a limited concept. And whenever, in fact, the co-partnership consists of 3 generations above and 3 generations below: father, grandfather, and great-grandfather, son, grandson, and great-grandson. These 6 degrees, they together constitute a co-partnership. And the female members, as I have already said, the wives of the co-partners and the unmarried daughters would be members of the joint family. And succession under Mithakshara is limited only to male members. In fact, the propinquity, the proximity of relationship with the original owner is the primary determining factor. The heirs are classified as sapindas, samanodakas, and bandhus. Among sapindas, they are either gotra sapindas or binna gotra sapindas, and samanodakas and bandhus. The nearer in degree exclude the more remote. So therefore, the concept is this. In fact, in all branches of law, the central point, it is individual centric, whereas in the Shastric Hindu law, it is not individual centric. It is either social centric or family centric. So it is, the family should be one. One should support the other. Somebody must manage the entire family properties. This is the concept. And the most important thing is that it is only in 1933 that the law of succession was partly codified by Mysore law, Women's Rights Act 1933. And under section 4 of that act, property would devolve upon the son, grandson, and great-grandson. For the first time, females are given a right of succession. The mother gets a right in the properties only in the absence of a son, grandson, and great-grandson. And the daughter would come into the picture in the absence of son, grandson, great-grandson, and the mother. If all these four persons are not there, then only the daughter would become a heir under Section 4 of this Mysore Law Women's Rights Act 1933. Under Section 8, a limited right is given to unmarried daughters and widows in the joint family. They will be entitled to a small share at a partition amongst the members of the family. They had no right to claim a partition. If a partition should take place amongst the members of the family, then only they would be entitled to a right at a partition in the joint family properties. Then the concept of Stridhana was also defined under Section 12 of the Act, and while succession to Stridhana, the sons and daughters are kept at par. If Stridhana properties devolves both upon the sons and daughters in equal share. And one more important factor is, prior to 1956, whenever a female acquired the property, she acquired the property basically for being enjoyed during her lifetime. It would not go to her successors in interest. The property would revert to the male heir on her death, and she had only a limited estate in what she acquired on succession to others. So this concept will have got to be clearly kept in mind. Then, in the old law, there was what was called a Jeshta Bhaga. In fact, at a partition amongst the members of the joint family, the eldest male member was given a little higher share than the other brothers in the family. Because he was obliged to perform the Shraddha of the elders. Number two, he was required to perform all the familial duties that were being followed by custom from the ancestors. And if any widowed daughter or such other person would come back to the joint family, it would be the duty of the Jeshta Putra to take care of such widowed persons who were incapable of taking care of themselves. So therefore, these special duties were given to the Jeshta Putra. It is just Jeshta Putra Pitru Samaha. That was one of the rules that was followed. Therefore, this concept of Jeshta Putra was, it is prevalent only in some areas of Mithakshara, and it is not prevalent in all, in the entire India, Then the widow had only a right to be maintained from the family estate. A husband was bound to maintain his wife. On his death, she has a right to be maintained from the estate of her husband. Where family property was partitioned, and if no provision was made to the widows in the family, widows of the co-parcellors in the family, then the widow could challenge the partition and ask for her maintenance rights to be preserved. Then the unmarried daughters, they had a right of maintenance till such time they were married. And they were also entitled to marriage expenses also. So therefore, all these things, though not they would be actually charged on the joint family properties, they were responsibilities to be taken care of by the joint family, especially by the manager of the joint family. So therefore, the law primarily looked at the welfare of the society, and in all persons in the joint family would be taken care of. It was not individual centric, no doubt. The manager was there. He would look to the needs of the family. He would look to the needs of every member of the family, and it was not individual centric. The emphasis was not on the rights of the members of the joint family. The emphasis was on the duties of the members of the joint family. This is, in fact, in all statutory Hindu law, the emphasis is only on rights. There are no duties. You can claim a right in the father's property, but what are your duties? Those duties are completely forgotten. So therefore, the emphasis was more on duties. The emphasis was more on security of all the members of the joint family. If somebody was unwell, if somebody was unable to work, if somebody was physically not able to maintain himself, all such persons would be taken care of by the head of the joint family from out of the funds of the joint family. Therefore, it was basically meant for the welfare of the entire family. So if the prosperity of the nation, in fact, the social security aspect was completely taken care of. There was no question of old people being thrown away from the house. There was no question of any old age homes. All these aspects would be taken care of in a joint family, because it was always felt that it was the responsibility of the joint family to take care of the entire joint family. Then, coming to the question of marriage, there are certain duties. The primary thing was, a marriage was not a contract. The marriage is sacrosanct. That means the relationship between husband and wife was not contractual at all. In all other societies, a marriage is primarily a contract. The purpose for marriage was, first is to perform the religious duties. In fact, if a person wants to perform a yajna or a homa, he cannot perform a yajna or homa without being accompanied by his wife. So therefore, for performing all these religious duties, the presence of the wife is obligatory. Therefore, for performance of these religious duties, a marriage is conducted. The second is procreation of children, especially a son, for continuation of the lineage. That was the second object. The third object is companionship and grihastha dharma. So therefore, the wife was given the duty of managing the entire home, the children, bringing them up, giving them proper religious education, giving them good moral education. Everything depended upon the wife. Therefore, the concept of a marriage being sacrosanct has been completely taken out after the Hindu Marriage Act 1955. In fact, now, see, a divorce was something which was unheard of in Shastric law. The bond of marriage was something which could not be dissolved at all. Then there the polygamy was permitted and polyandry was not permitted. If a male person could have more than one wife, and a female could not enter into a second marriage. This was the law earlier. In fact, you look at that concept. See if you go back about 50, 60 years back, hardly there were few people who had a second wife. In fact, the first and second wife, they lived together under the same roof. All the children of the first wife and the second wife, they were being taken care of by the joint family. And all these children, they have an equal right by birth. The children, the equal right by birth in the joint family properties. In fact, see, therefore, see, everything was open. There was nothing like having an illicit relationship or a live-in relationship and something like that. And the situation may arise where the son may not know who the father is. That is the situation with how the law is interpreted by expanding what is personal liberty under Article 21 of the Constitution. Now, there was also one other factor and under old law which has got to be kept in mind. Suppose a person had an illicit relationship. Even then, the law recognized that the children of exclusive concubines, they have also a right in the properties. So therefore, there was no hide and seek. In fact, the primary concept was to have only one wife. Rama was the ideal for everybody. But in certain situations, we do not know what was the sexual drive of that male, what was the necessity. It could be even in some cases, the first wife did not have children. The first wife did not have a male issue because the lineage must continue. For all these reasons, a second marriage was legal under the old Shastric Hindu law. So therefore, the law took care of all situations that would arise. And the son born, everybody knew that who is the father and who is the mother. There was no difficulty about it at all. In England, I am told, if somebody asks, who is your father? The son will reply, I am reputed to be the son of so-and-so. Such a situation was never there under the old Shastric Hindu law. Now, coming back to the current, then this child marriage was also permitted. Yeah, and it was only in 1829 that the Child Marriage Restraint Act was brought into force. It was on 1856. In fact, though a child marriage was prohibited and the parties to the marriage were liable to be punished, the marriage was not void. The marriage was only voidable under certain situations. And that was before. See, when Hindu Marriage Act was brought into force, President Rajendra Prasad was the president. He was a devout Hindu. He felt that the concept of marriage under the old Hindu law was being given a complete go-by. Though the marriage was called a sacrament, the sacrament part of the marriage was completely taken away from the Hindu Succession Act. Therefore, it appears that this Rajendra Prasad consulted the then Attorney General M.C. Settleward to find out whether the president has the power to completely refuse assent to the bill. So the Hindu Marriage Act does not come into force at all. But he was advised that he was bound by the advice of the Council of Ministers, therefore he gave assent to the bill. So therefore, if you look at the provisions of the Hindu Marriage Act, see, you will certainly see that the Shastric part of the marriage, the object of the marriage, has been completely taken out. You can call it Marriage Act, don't call it Hindu Marriage Act. So therefore, see, the law almost gives the marriage a tinge of contract and nothing more than that. In fact, why do you see the divorce by consent, divorce, and any adult can have a relationship with another adult female, and all those things, they were never heard of, and those are all foreign concepts of individual liberty. The foreign concepts of individual liberty has been put into the Hindu Marriage Act, and that law has further been enlarged by the Supreme Court by application of Article 21. In fact, see, they say, there is one thing, many people say that Nastri Swatantra Marhati. This is what is said. It is, see, look at what is there in the earlier part of the sloka. It says, during childhood, she has got to be taken care of by the mother. After marriage, the husband should take care of her. In her old age, the son should take care of her. See, the physical disabilities of a female. In fact, she cannot protect herself from onslaughts by very strong persons. If they have got to be protected, there must be somebody to protect her. In fact, in earlier days, if young children went out of the house, they would normally be accompanied by either the father or the elder brother or somebody else. If a married lady should go about, she would be accompanied by her husband. Old people certainly are helped by the children. In fact, this is only a social security system that was developed at that time. In fact, women were never disrespected under the old law. See, the first thing is Matru Devo Bhava. You respect your mother. Then Pitru Devo Bhava. Then Acharya Devo Bhava. Therefore, these social concepts, which were not individual-centric under the old law, have now gained importance, and practically the entire Hindu law is sidelined. And my feeling is we should give a second thought and find out what is required for the society and what should be done and what should be the law. Even in respect of, you see, right by birth. In fact, after the amendment of the Hindu Succession Act, the daughter was entitled to a share only in the property of the father, which he would have got at partition on the date of his death. Therefore, the son got a higher share, a share by birth, in addition, a share on succession to his father, whereas the daughter only got a share on succession to the father. This was the earlier rule. Then, after the amendment in the year 2005, the daughter is also given the status of a co-partner. Then look at this from a different angle. Suppose a daughter is not given a share in the father's property. What happens? The daughter does not get a share in his father's property, whereas in her husband's family, so the daughter does not get a share. Therefore, the son-in-law gets a higher share in that family. Here, the son gets a higher share in the family. Therefore, in totality, the husband and wife together, they are not deprived of the family property at all. So you must look at this from angle. What she lost in her father's estate, her husband derived benefit from her father-in-law's estate. So the totality of the family is not lost. See, the most important thing is there must be peace in the family. There must be peace in the society. The husband and wife must be looked at as one unit. The relationship between the brother and the sister must never be hampered. Therefore, the concept of individual-centric, that I should have a right in the property, is an egocentric approach. And according to me, you should have a family-centric approach. And we find today large number of suits being filed by daughters. The relationship in the family is lost. The son is not on talking terms with the daughter. Look at olden days. At least the brother was required to meet the sisters of our Gauri festival. He would meet. He would part with whatever he wanted to give to the sisters. On Nagara Panchami, the sisters would come to the brother. She would give whatever she could afford to his brother. This cordial relationship in the family is to be maintained, and the law should feed this relationship. The law has failed to do it, and we have tried to ape the Western concepts into Hindu law, and that, according to me, requires a relook, and we have got to look at all these matters. In fact, all Shastric Hindu law or the concepts of rishis, they had nothing to do with any family. They had no individual interest. They were people who could imagine situations, and they were guided by Vedic precepts. And what they said is for the entire world and for all times to come. This has been completely forgotten. Therefore, I would always say that we should make a research and try to find out. The family should be one. Relationship should be fine. Husband and wife should get on. They should get on very well. See, you look at the whole world, even at the state level, there is a prime minister. He is the head of the family. There are different people look after different departments. Likewise, in a joint family, the eldest member is the manager of the family. The woman is actually the home minister. She takes care of everything. In fact, I was reading the biography of Alladi Ramaswamy, and it appears when he was practicing as an advocate in Madras, every client who came to his house, he would be fed in the house. And it was the duty of his wife to take care of all these clients also who came to the house. In fact, Alladi Kriswamy said he was giving her every month 3,000 rupees for feeding all the, looking after the family. And she used to tell his wife, I am giving you 3,000 rupees, and that is much more than the salary of a high court judge. This was what he was telling his wife at that time. Therefore, see, if the family is happy, the society is happy, the nation is happy, and we have got, in fact, in our education system, the moral aspect has been completely taken off. And unless the system is changed and morals are injected into the young blood, our society will not change. There will be a lot of violence, violence will increase, and the society is going to be shattered. In fact, see, when I was a small boy, I still remember my Sanskrit teacher telling me, these are the qualities of Rama. See, he used to tell me one thing. See, you have one quality of Rama in your mind, and you try to follow that one quality, you will be a great man in life. That was what he used to tell me. In fact, one quality that has always struck me is Purva Pasita Raghava. Anybody may talk to you or not talk to you. No, they may respect you or not respect you. You talk to him with a smiling face. See, what a fine, every character. In fact, see, why Ramayana, Mahabharata? See, why do you say that they are Hindu texts? Nothing should be followed in education. See, take out what is good, give what is good in every kind of sacred text. In fact, environment. See, if I go and see Ganga, I prostrate before Ganga, and we never spit in the Ganga. We never wash clothes in the Ganga. So all this environmental is in our mind. In fact, you cannot cut one tree in your lifetime. In fact, the Shastras prescribe, if you want to cut a tree, you will have to perform a homa. And further, if you are taking out one tree, you should plant 4 trees. You look at what is stated in the Shastras. In fact, I would say I have built a happy family around myself only because my wife is also an advocate. She practiced for 1 year. Thereafter, we had children in the family. She gave up the practice 100%. She has never walked into my office at any time. She has taken care of my children. She has taken care of their education. She has taken care of their welfare. She has brought them up well. It is her credit. She is the home minister of the house. And because she is the home minister of the house, I have been able to develop myself as a fairly good lawyer. She is behind my back. In fact, if she had said, I also want to practice, I also want to achieve something, I also have my own income, then things would have been completely different. Therefore, the basic aspect must be first the happiness in the family. That should develop. If that is developed, the society will be happy, the country will be happy, and that was the basic principle on which the entire law stood. And this has got to be restored, according to me. I think I have overshot my time. Thank you very much for having given me an opportunity to speak on an occasion like this. And I knew Mr. Rama Joyce even before he became a judge. Because my family was associated both with RSS and Jansangh, he had come to my house. He was my professor in law. He has taught me legal history and constitutional history. And he was my guru also. And therefore, I bow my head to Mr. Rama Joyce. Apart from that, I have a special date. It's a special day today for me. I was enrolled on 31st July 1971. Today I complete 55 years. I want the wishes of all of you for me to continue and give something to the society from even for further years to come. Thank you. Thank you very much.
Thanks a lot, sir. In fact, we are delighted to tell our audience that Shri Surya Narayan Rao was very recently been honored and awarded by His Lordship Justice M.N. Venkatachalaya, an award named Legal Luminary Award, which he very definitely deserves it. Thanks for this very enriching and enlightening lecture, sir. There were very interesting things that you have again introduced us. The new generation is now introduced to the real reasons behind why there were laws earlier in the earlier era and what are the lacunas in the present legal system and the laws of the present day, which we all together can discuss and think, and if necessary, again bring some reforms to tune ourselves with the real correct laws, which will keep all of us progressing in the society. May I now request, since we are running out of time, it is already 7:30. May I request Sri Prahlad Joshi, Honorable Vice Chancellor, to directly present his presidential remarks. I would seek a pardon of our trustee Sri Vasudev Sedam to permit me to skip his talk for a moment and then request Sri Prahlad Joshi, sir. At this, before he begins, I also again want to acknowledge the presence of advocates Sri Anu Chengappa from Bengaluru High Court, Sri S. Chandrasekhar, Principal of Siddharth Law College, and very enthusiastic personals here, all principal staff, Madam Renuka Madam and others also who have joined us. Please, sir.
जयति पराशर सूनुः सत्यवती हृदय नंदनो व्यासः यस्य आस्यकमलगलितं वाङ्मयममृतं जगत्पिबति। नमस्सभायै। अद्य वयं सर्वेपि अत्र सम्मिलिताः महोदयस्य विशेषरूपेण सूर्यनारायण राव महोदयस्य अद्भुतं भाषणम् अस्माभिः श्रुतम्। अतः महोदयस्य कृते आदौ धन्यवादान् समर्पयामि। Sir, my mother tongue is Kannada, but as I am working in this Sanskrit University, actually I am working in Rashtriya Sanskrit Vishwavidyalaya Tirupati. From there I am on deputation for this Sanskrit University, the one and only university in Northeast, entire Northeast. Kumar Bhaskar Verma, as all of you know, the great king. He served the Kamarupa kingdom, which is called as Pragjyotishapura, for 50 years. He was unmarried, so he is called as Kumar Bhaskar Verma. He was not married, and he brought nearly about 200 Vedic Pandits from Mithila to this part of country, and he gave them Bhudana also, which is recorded. Even it was available in, it was found in Nidhanapura, which is now in Bangladesh, where the beneficiaries, 200 Vedic Pandits, the beneficiaries' name was written there, and their name, Gotra, Pravara, and Veda Shakha, everything is recorded. And this was brought by Mukunda Madhava Sharma, the first Vice Chancellor of Guwahati University. The manuscript is that manuscript. It was actually a Tamra Shasana, and it is available in Guwahati University library. So why I am mentioning all these things? Because with regard to Sanskrit, this part of country, most of the people don't know. I am in Nalbari district, which is once very famous for Ulfa activities, nerve center of Ulfa in those days. Now it is called Pragnya Nagari also. The university is established by state government of Assam in this part, because in the only Nalbari district, you will find nearly 100 Sanskrit scholars. I have not heard anywhere in only Nalbari district, entire Assam. It's a lower Assam, 100 Sanskrit scholars we find here. And one, the great scholar Mahamohopadhyaya, Dhireshwaracharya, was also here. He used to give lectures in poetic form only, not in prose form, in poetic form. Once he was challenged in Calcutta Sabha. See, you people just write something, by heart something, and you will deliver. But today you have to speak spontaneously. So he has been given a challenge to speak in Bhujanga Prayata, that word Chandas, Bhujanga Prayata Chandas. So he started Amushyam Sabhayam Mamaisha Pratignya Bhujanga Prayatam Vinavag Nabhasha. No, he started like that. That type of scholars, Mahamohopadhyaya were here. Just why I'm telling all these things, because it is a Sanskrit university here. We have 9 departments. Veda department we have. In Veda Vedanga we have Veda, the second department is Dharma Shastra, where we teach Manusmriti, Parashara Smriti, Yajnavalkya Smriti, and all these things. And with the help of our Mahadeva ji, whom I know from my childhood, because I was living in Gulbarga, very in the Vitthal Nagar, where near to my Sangha Karyalaya also, we used to, I mean, these people have motivated us. So Mahadeva ji told, so whenever you organize any program, especially Dharma Shastra department, they organize workshops and all those things. So now they have started introducing this Mithakshara written by Vijnaneshwara. Earlier it was not in practice. Though they used to tell just original text and some, because Dharma Shastra, Kamarupa Dharma Shastra is something different. Assam, they have something different also. They follow this Daya Bhaga, because it is the entire belt of Bihar, West Bengal and Assam, the same culture we can see. So we are trying our best to start these, I mean, courses in our university. Last year, we have started Ancient Indian Jurisprudence, LLM, Master of Laws in Specialization, Ancient Indian Jurisprudence. And the first batch, recently they have concluded, 24 students joined in that course. The speciality of this program is there are 4 semesters. In each semester, one Sanskrit paper is compulsory for them. So that the students of law should also know Sanskrit. As our Honorable Speaker Sir has told, Nastri Swatantra Marhati. The earlier people take only one part of it. It's only one pada. Pita rakshati kaumare, bharta rakshati yavane, savire rakshanti putraha, Nastri Swatantra Marhati. This is the complete shloka. And people take the last part and they start, the Manu has not given freedom to women and all those things. But actually in the same text, you can find Yatra naryastu pujyante tatra ramante devataha. Manu himself says, where there is, we worship the women. Yatra naryastu pujyante tatra ramante devata. All gods will bless you. The same Manu has told. The very actually, Manu, what he says, she cannot protect herself. Rightly said by our honorable speaker. She cannot protect at any level. In childhood, the father will protect her. After marriage, husband will protect her. And at the age, when she is aged, and the children will protect her. This was what told. But the people will misinterpret all these things. So today I'm very happy to listen to Suryanarayan Rao. Very elaborately he has mentioned. And my relation with this is, I belong to Karnataka and Marturi is just 15 kilometers away from Kalaburgi. So I feel very proud that I am also from a place where Vijnaneshwara born and who wrote Mithakshara in that way. So I am very much thankful to all of you. And whenever possible, I requested Mahadeva sir also, any judge advocates comes over to Guwahati for any purpose, or otherwise we also invite them to deliver lectures here, because people here, most of them have not crossed Brahmaputra river. Most of them, they are in isolated place. Still, they have that feeling that Bharat wahan par hai, hum itne dur hai. They differentiate themselves that they are not part of India. Now the things are changing. It's very peaceful area here. Anybody can live here. Earlier, when I appointed, my wife said, don't go there, because Nalbari is synonym to Ulfa activities. It was so much. So earlier people, luckily one of my students was IPS officer here. He told that, sir, nothing to worry, you can come over here. So this is what happened. So once again, I thank, and I read the commentary. It was published by our university, Tirupati University, from Rama Joy sir book. The English commentary was also published by Rashtriya Sanskrit Vishwavidyalaya Tirupati. If anybody is interested, they can purchase. So once again, I thank all of you, and special thanks to the Suryanarayan Rao sir. Very good lecture he has given. We learned a lot of things. Thank you very much. Thank you.
That was so nice of you, sir, to invite all of us or some of us to your university. We also take pride in your position there in the university. We also now invite on behalf of all the organizers, especially Vijnaneshwara Pratisthana Trust, that all the judges, the academicians and advocates, all of them, and students, please visit Martur in Kalburgi district, and then please experience the vibrations, the positive vibrations of that particular research bhavan there. With this, we have come to the penultimate stage of our today's program. May I now request Sri Mahadevaya ji to take over the.
ನಮಸ್ಕಾರ. ಡಾಕ್ಟರ್ ವಾಸುದೇವ್ ಸೇಡಂ ಅವರು ಒಂದೆರಡು ಮಾತುಗಳು ಹೇಳ್ಬೋದು ಅಂತ ಅನ್ಸುತ್ತೆ. ಟೈಮ್ ಶಾರ್ಟ್ ಟೈಮ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ ಹೇಳ್ಬೋದು.
ಸರ್, ಬಹಳ ಖುಷಿ ಆಗ್ತದೆ, ಬಹಳ ಅಭಿಮಾನ ಪಟ್ಕೊಳ್ತೀನಿ. ಜಸ್ಟಿಸ್ ರಾಮ ಜೋಶಿ ಅವರ ಮಾರ್ಗದರ್ಶನದಲ್ಲಿ 2 ದಶಕಗಳಿಂದಲೂ ನಾವು ಹಲವಾರು ಕಾರ್ಯಕ್ರಮಗಳನ್ನು ಹಾಕಿಕೊಳ್ತಾ ಬಂದಿದ್ದೇವೆ. ಇವತ್ತಿನ ದಿವಸ ಸೂರ್ಯನಾರಾಯಣ ರಾವ್ ಸರ್ ಅವರು ಬಹಳ ಎನ್ಲೈಟನ್ ಮಾಡಿದರು. 2 ಸ್ಕೂಲ್ ಆಫ್ ಲಾ ಬಗ್ಗೆ ಹೇಳಿದರು. ಒಂದು ಮಿಥಾಕ್ಷರಿ ಸ್ಕೂಲ್ ಆಫ್ ಲಾ, ದಾಯಿಭಾಗ ಸ್ಕೂಲ್ ಆಫ್ ಲಾ. ಇವೆರಡರ ಬಗ್ಗೆ ಅವರು ಯಾವ್ಯಾವ ರೀತಿಯಾದಂತ ಲಾಭಗಳು ಆಗಬಹುದು ಅಂತಕ್ಕಂಥದ್ದನ್ನ ಹೇಳಿದರು. ಇಲ್ಲಿ ನಾವು ಸರ್ ಹೇಳಿದ ಹಾಗೆ ನಮ್ಮ ಹಿಂದೂ ಲಾ ಈಸ್ ಬೇಸ್ಡ್ ಆನ್ ಬೇಸಿಕಲಿ ಧರ್ಮಶಾಸ್ತ್ರ. ಆ ಧರ್ಮಶಾಸ್ತ್ರದ ಪ್ರಕಾರನೇ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಆಗ್ತವಂತ ನಾನು ಅನ್ಕೊಂಡಿದ್ದೀನಿ. ಒಂದು ಕಡೆಗೆ ಹೀಗೆ ಹೇಳ್ತೀವಿ, ಲಾ ಕ್ಯಾನ್ ರಿಮೇನ್ ಫೇರ್ ವೈಲ್ ಸ್ಟಿಲ್ ರೆಸ್ಪೆಕ್ಟೆಡ್ ಹ್ಯೂಮನ್ ಡಿಗ್ನಿಟಿ ಅಂಡ್ ಕಂಪ್ಯಾಷನ್ ಅಂತಕ್ಕಂಥದ್ದನ್ನ, ಆ ಒಂದು ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಇವತ್ತ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗ್ತಾ ಇರೋದು ಇಂಡಿಯಾದಲ್ಲಿ ಬಹಳ ಖುಷಿ ಆಗ್ತದೆ. ನಾನು ಬಹಳಷ್ಟು ಹೇಳೋದಕ್ಕೆ ನಾನು ಹೋಗೋದಿಲ್ಲ. ಈಗ ನನಗೆ ಅವಕಾಶ ಕೊಟ್ಟದಕ್ಕೆ ನಮಗೆಲ್ಲರಿಗೂ ತುಂಬ ಹೃದಯದ ನಮಸ್ಕಾರಗಳು.
ನಮಸ್ಕಾರ. ಇವತ್ತಿನ ದಿನ 6ನೇ ವರ್ಷ ಇದು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮತ್ತು ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕರ್ನಾಟಕ ಮತ್ತು ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಲಾ ಯೂನಿವರ್ಸಿಟಿ ಒಟ್ಟಾಗಿ ಸೇರಿ ಒಂದು ಪ್ಲಾಟ್ಫಾರ್ಮ್ ಅನ್ನ ಆಧುನಿಕ ಮತ್ತು ಸನಾತನ ಭಾರತೀಯ ನ್ಯಾಯ ದರ್ಶನ ಕೂಡ ಚಿಂತನೆ ಮಾಡ್ತಕ್ಕಂಥ ಒದಗಿಸ್ತಕ್ಕಂಥ ಪ್ಲಾಟ್ಫಾರ್ಮ್ ಇದು. ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಶ್ರೀಯುತ ಸೂರ್ಯನಾರಾಯಣರವರು ತಮ್ಮ ಅನುಭವಪೂರ್ಣ ಮಾತುಗಳನ್ನ ಹೇಳಿ ಧರ್ಮಶಾಸ್ತ್ರದ ಬಗ್ಗೆ ಇರ್ತಕ್ಕಂಥ ವಿವರಗಳನ್ನ ವಿಶದವಾಗಿ ತಿಳಿಸೋದಕ್ಕೋಸ್ಕರ ಅವರಿಗೆ ನಾನು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ, ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿ ಮತ್ತು ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಲಾ ಯೂನಿವರ್ಸಿಟಿ ಪರವಾಗಿ ಪೂರ್ವಕ ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತೇನೆ. ಸದಾ ನಮ್ ಜೊತೆಯಲ್ಲಿದ್ದು ನಮ್ಮವರೇ ಆದಂತ ಪ್ರಹ್ಲಾದ್ ಜೋಶಿ ಅವರು ಕರೆದಾಗೆಲ್ಲ ರೆಡಿ ಬರ್ತಾರೆ. ಮತ್ತೆ ಅವ್ರು ಹೇಳಿದಾಗ ಇತ್ತೀಚೆಗೆ ಕರ್ನಾಟಕದ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದ ನ್ಯಾಯಮೂರ್ತಿ ಇಂದ್ರೇಶ್ ಅವರು ಅವ್ರ ಕಾರ್ಯಕ್ರಮವನ್ನು ಅವ್ರು ಏರ್ಪಡಿಸಿದ್ರು. ಈ ರೀತಿ ಯಾವ್ದು ಪೂರ್ವಾಂಚಲ ಅವ್ರು ಹೇಳಿದಾಗೆ ಭಾರತದ ಬೇರೆ ಜನ ಭಾವಿಸ್ತಾರೆ, ಆ ಕೊರತೆಯನ್ನು ತುಂಬಲಿಕ್ಕೆ ಅವ್ರು ಸತತ ಪ್ರಯತ್ನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಒಳ್ಳೆ ಉತ್ತಮ ಉಪನ್ಯಾಸ ಏರ್ಪಡಿಸಿದ್ರು ಎಲ್ಲ ವಿದ್ಯಾರ್ಥಿಗಳಿಗಾಗಿ. ವಿಜ್ಞಾನೇಶ್ವರ ಗಡಿಯ ಕೊನೆಯವರೆಗೂ ಮುಟ್ಟಿದ್ರು ಅನ್ನೋದು ನಮ್ಗೆ ಹೆಮ್ಮೆ ತಂದಿದೆ. ಅದೇ ರೀತಿ ಇವತ್ತಿನ ಕಾರ್ಯಕ್ರಮದ ನಮ್ಮ ವಿಶ್ವಸ್ತರಾದಂತ ಡಾಕ್ಟರ್ ವಾಸುದೇವ್ ಸೇಡಂ, ನಮ್ಮ ಗೌರವಾನ್ವಿತ ಅಧ್ಯಕ್ಷರಾದಂತ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂ ಮತ್ತು ಸುರೇಶ್ ಬುಲ್ಬುಲಿ ಅವರು, ಅಮಿತ್ ದೇಶಪಾಂಡೆ ಅವರು, ಎಸ್ ಸಿ ಪಾಟೀಲ್ ಸೇರಿದಂತೆ ಎಲ್ಲ ವಿಶ್ವಸ್ತರಿಗೂ ನಾನು ಕೃತಜ್ಞತೆಗಳನ್ನು ತಲುಪಿಸ್ತೇನೆ. ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಸಕ್ರಿಯವಾಗಿ ನಮಗೆ ಸಹಕಾರ ಕೊಡ್ತಕ್ಕಂತ ಕುಲಪತಿಗಳಾದಂತ ಭಟ್ಟು ಸತ್ಯನಾರಾಯಣರವರು, ಡೀನ್ ಆದಂತ ಕೂಕಡ್ಡಿಯವರು, ಅವರ ಸಿಬ್ಬಂದಿ ವರ್ಗ, ಹಾಗೆ ಸ್ಟೇಟ್ ಲಾ ಯೂನಿವರ್ಸಿಟಿಯ ಮಾನ್ಯ ಗೌರವಾನ್ವಿತ ಕುಲಪತಿಗಳಾದಂತ ಬಸವರಾಜ್ ಅವರು, ಗಿರೀಶ್ ಅವರು, ಅವರ ಸಿಬ್ಬಂದಿಯವರು, ಎಲ್ಲರಿಗೂ ನಾನು ನಮ್ಮ ಪರವಾಗಿ ಪೂರ್ವಕ ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತೇನೆ. ಹಾಗೆ ಇವತ್ತಿನ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ನಮಗೆ ಸಹಕಾರ ನೀಡಿದಂತ ಕೃಷ್ಣ ಅವರ ಬದಲಾಗಿ ಘೋಷ್ ಅವರು ಇವತ್ತು ನಮಗೆ ಸಹಕಾರ ನೀಡಿದರೆ ತಾಂತ್ರಿಕ ಸಹಾಯ, ಅವರಿಗೂ ಕೂಡ ನಾನು ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತೇನೆ. ಇವತ್ತಿನ ತುಂಬಾ ಜನ ಗೌರವಾನ್ವಿತ ನಮ್ಮ ಜೊತೆ ಸೇರಿದ್ದಾರೆ. ವಿಶೇಷವಾಗಿ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದ ಸಂಜೀವ್ ಕುಮಾರ್ ಅಂಚಾಟಿ ಅವರು, ಮುಂದಿನ ಉಪನ್ಯಾಸ ನೀಡಿರ್ತಕ್ಕಂಥ ಪಿ ಕೃಷ್ಣನ್ ಮತ್ತು ಅವರ ತಂಡದವರು, ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿಯ ರೇಣುಕಾ ಮೇಡಮ್ ಅವರು, ಈ ರೀತಿ ಬೇರೆ ಬೇರೆ ಜನ ತುಂಬಾ ಜನ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ. ಎಲ್ಲರಿಗೂ ಕೂಡ ಹೆಸರು ತಗೊಳ್ಳಾರದೆ ಹೇಳೋದಕ್ಕೆ ನಾನು ಸಮಯ ಅಭಾವದಿಂದ ಅವರೆಲ್ಲರಿಗೂ ನಾನು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದ ಪರವಾಗಿ ತುಂಬ ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ತಿಳಿಸ್ತೇನೆ. 3ನೇ ತಾರೀಕು ಇದೇ ವೇದಿಕೆಯಲ್ಲಿ ಇದೇ ಲಿಂಕ್ ಅಲ್ಲಿ ನಾವು ಮತ್ತೆ ಸೇರಿದ್ದೀವಿ. ದಯವಿಟ್ಟು ಹೆಚ್ಚು ಜನಗಳನ್ನು ಸೇರಿಸಬೇಕು ಅಂತ ಮತ್ತೊಮ್ಮೆ ವಿನಂತಿ ಮಾಡ್ಕೊಳ್ತೇನೆ. ಯಾಕಂದ್ರೆ ಸತ್ ವಿಚಾರಗಳನ್ನ ನಾವು ಮನೆಯವರೆಗೆ ಹೋಗಿ ಕರ್ಕೊಂಡು ಬರ್ಬೇಕು. ನಿಮ್ಗೆಲ್ಲ ಗೊತ್ತಿದೆ, ಹಾಲು ಕುಡಿಬೇಕಾದ್ರೆ ಹಾಲು ನಾವು ಮನೆಗೆ ತಂದು ಕೊಡ್ತಾನೆ. ಆಲ್ಕೋಹಾಲ್ ನಾನು ಇದ್ದಲ್ಲಿ ಹೋಗಿ ಕುಡಿತೇವೆ. ನಾವು ಹಾಲು ಕುಡಿಸ್ಬೇಕಾದ್ರೆ ಪ್ರತಿಯೊಬ್ಬ ಪ್ರಜೆಗಳ ಹತ್ರ ಹೋಗ್ಬೇಕು. ಇಸ್ ದ ಬಾಂಡ್ ಅಂಡ್ ಡ್ಯೂಟಿ ಆಫ್ ಎಲೈಡ್ ಸಿಟಿಜನ್ಸ್. ಅವ್ರನ್ನೆಲ್ಲ ಹತ್ರ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು, ಅವ್ರನ್ನ ಈ ಸಂಘದಲ್ಲಿ ಜೋಡಿಸ್ಬೇಕು. ಭಾರತೀಯ ನ್ಯಾಯ ಪರಂಪರೆಯನ್ನ ಪ್ರಸ್ತುತಪಡಿಸಿ, ಆಧುನಿಕ ನ್ಯಾಯ ಪದ್ಧತಿಗೆ ಅನುಗುಣವಾಗಿ ಪ್ರಸ್ತುತಪಡಿಸಿ ಕಿರಿಯರಲ್ಲಿ ಅದು ಉತ್ಸಾಹ ಮೂಡಿಸ್ಬೇಕು. ಒಂದು ಮಾದರಿಯ ನ್ಯಾಯ ಪದ್ಧತಿ ಆಗ್ಬೇಕನ್ನೋ ಪ್ರಯತ್ನ ನಮ್ ನಡೆದಿದೆ. ವಿವಿಧ ಹಂತಗಳಲ್ಲಿ ತರಬೇತಿ ಯೋಚನೆ ಮಾಡ್ತಾ ಇದ್ದೇವೆ. ಸೊ ಈ ದಿಶೆಯಲ್ಲಿ ಮೊನ್ನೆ ಗೌರವಾನ್ವಿತ ಕುಲಪತಿಗಳು ಒಂದು ವೆಬ್ಸೈಟ್ ಅನ್ನ ಬಿಡುಗಡೆ ಮಾಡಿದ್ದಾರೆ. ಅದು ದೇಶಪಾಂಡೆ ಅವ್ರದ್ದು ಲಿಂಕ್ ಹಾಕ್ತಾರೆ, ಅದನ್ನ ನೋಡ್ಬೋದು. ಅದೇ ರೀತಿ ಒಂದು PPT ಅನ್ನ ಕೂಡ ನಾವು ರಿಲೀಸ್ ಮಾಡಿದ್ದೇವೆ. ಎಲ್ಲರೂ ಅದನ್ನ ನೋಡ್ಬೇಕು. ನಿಮ್ಮ ಸಲಹೆಗಳಿಗೆ ಸ್ವಾಗತ, ನಿಮ್ಮ ಸಹಕಾರಗಳಿಗೆ ನಾವು ತುಂಬಾ ಹೃದಯದ ಸ್ವಾಗತ. ರಾಜ್ಯಾದ್ಯಂತ ದೇಶಾದ್ಯಂತ ಎಲ್ಲರೂ ಬಂದಿದ್ದಾರೆ, ಪ್ರಾತಿನಿಧಿಕ ಅಂತ ನಾನು ಭಾವಿಸ್ತೇನೆ. ಬಂದವರು ಎಷ್ಟೇ ಜನ ಇರಲಿ, ಆದ್ರೆ ತುಂಬಾ ಆಸಕ್ತಿಯಿಂದ ಬಂದರೆ ಅವರೆಲ್ಲರಿಗೂ ನಾನು ಮತ್ತೊಮ್ಮೆ ಧನ್ಯವಾದಗಳು. ಓವರ್ ಟು ಅಮಿತ್ ಕುಮಾರ್.
ಧನ್ಯವಾದ ಎಲ್ಲರಿಗೂ. ಶಾಂತಿ ಮಂತ್ರದಿಂದ ಇದನ್ನ ವಿ ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್ ಸರ್. ಮಹಾದೇವಯ್ಯ ಅವರು ಶಾಂತಿ ಮಂತ್ರ ಅಂತಿರೋ, ಇನ್ನು ನಾನು ಅನ್ಬೇಕು? ಆಯ್ತು. ಓಂ ಹೇಳಿ ಸರ್.
ಸರ್ವೇ ಭವಂತು ಸುಖಿನಃ, ಸರ್ವೇ ಸಂತು ನಿರಾಮಯಃ, ಸರ್ವೇ ಭದ್ರಾಣಿ ಪಶ್ಯಂತು, ಮಾ ಕಶ್ಚಿತ್ ದುಃಖಭಾಗ್ ಭವೇತ್.
ಓಂ ಶಾಂತಿ ಶಾಂತಿ ಶಾಂತಿ. ಎಲ್ಲರಿಗೂ ತುಂಬ ಹೃದಯದ ಧನ್ಯವಾದಗಳು. ಟೈಮ್ ಸರಿಯಾಗಿ ಮುಗಿದಿದೆ. ರಿಸೋರ್ಸ್ ಪರ್ಸನ್ ಏನಾದ್ರು ಇದ್ರೆ ಒಂದೆರಡು ಯಾರಾದ್ರೂ ವಿಶೇಷ ಕ್ವಶನ್ ಇದ್ರೆ ಕೇಳ್ಬೋದು ಅವ್ರಿಗೆ. ಯಾಕಂದ್ರೆ ಇನ್ನು 5-10 ನಿಮಿಷ ಅವ್ರು ಏನಾದ್ರು ಸ್ಪೇರ್ ಮಾಡ್ತಿದ್ರೆ, ಯಾರಿಗಾದ್ರೂ ಅವಕಾಶ ಬೇಕಿದ್ರೆ ಒಂದು ಮಾತು ನಾನು ವಿನಂತಿ ಮಾಡ್ಕೊಳ್ತೇನೆ. ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಗಳಿಗೆ ಸ್ವಲ್ಪ ಇದ್ದವ್ರು ಏನಾದ್ರು ಕ್ವಶನ್ ತಗೋತಿದ್ರೆ ಯಾರಿಗಾದ್ರೂ ಅವಕಾಶ ಇದೆ. ಸೂರ್ಯನಾರಾಯಣ ಸರ್ ಇದೆ ಸರ್, ಯಾರಾದ್ರೂ ಕ್ವಶನ್ಸ್ ಕೇಳ್ತಾರೆ ಕೇಳ್ಬೋದು ಇದ್ದವ್ರು. ಕೇಳ್ಬೋದು ಒಂದ್ 5 ನಿಮಿಷ ಒಂದೊಂದ್ಸಲ ವಿಶೇಷವಾಗಿರ್ತಾರೆ. ಏನಾದ್ರು ಆತರ ವಿಶೇಷವಾಗಿ ಕ್ವಶನ್. ಭಾರತೀಯ ನ್ಯಾಯದಲ್ಲಿ ಧರ್ಮಶಾಸ್ತ್ರ ಸಂವಾದದ ಮೂಲಕನೇ ಆಗಿದೆ. ಸಂವಾದವನ್ನ ಪ್ರೋತ್ಸಾಹಿಸಲುವಾಗಿ ಅದರ ಟೈಮ್ ಲಿಮಿಟ್ ಅಲ್ಲಿ ನಮ್ಮ ಕಾರ್ಯಕ್ರಮ ಮುಗಿಸ್ಬೇಕಾದ್ ಮುಗಿಸಿದ್ವಿ. ಆದ್ರೆ ಸನ್ಮಾನ್ಯರು ನಮ್ಮ ಒಟ್ಟಿಗಿರೋದ್ರಿಂದ ಒಂದೆರಡು ಕ್ವಶನ್ ಕೇಳ.
ಸರ್, ನಾನೊಂದು ಪ್ರಶ್ನೆ ಕೇಳೋಣ ಅಂತ.
ಹೇಳಿ.
ಇದು ಮದುವೆ ಆಗದೇ ಇದ್ದ ಹೆಣ್ಮಕ್ಳಿಗೆ ಆಸ್ತಿಯಲ್ಲಿ ಭಾಗ ಸಿಗುತ್ತಾ ಇಲ್ವೋ?
ಮದುವೆ ಆಗದೆ ಇರ್ತಕ್ಕಂಥ, ನೀವು ಹೊಸ ಕಾನೂನಿನ ಪ್ರಕಾರ ಕೇಳ್ತಿದ್ದೀರೋ ಹಳೆ ಕಾನೂನಿನ ಪ್ರಕಾರ?
ಈಗ ಸದ್ಯ ಇರುವ ಕಾನೂನು ಹೇಗೆ?
ಈಗಿರುವ ಕಾನೂನು ಪ್ರಕಾರ ತಂದೆ ಸ್ವಯಾರ್ಜಿತ ಆಸ್ತಿಯಲ್ಲಿ ಅವರಿಗೆ ಸಮಭಾಗ ಇತ್ತು, ಸ್ವಯಾರ್ಜಿತ ಆಸ್ತಿಯಲ್ಲಿ. ಇವಾಗ 2005ರಲ್ಲಿ ಕಾನೂನು ಬದಲಾವಣೆ ಆದ ಮೇಲೆ ತಂದೆಯ ಪಿತ್ರಾರ್ಜಿತ ಆಸ್ತಿಗಳಲ್ಲೂ ಕೂಡ ಮಗನಿಗೆ ಏನ್ ಭಾಗ ಬರುತ್ತೋ ಅದು ಅನ್ಮ್ಯಾರಿಡ್ ಡಾಟರ್ ಆಗ್ಲಿ ಮ್ಯಾರಿಡ್ ಡಾಟರ್ ಆಗ್ಲಿ ಎಲ್ರಿಗೂ ಕೂಡ ಸಮಭಾಗನೇ ಬರುತ್ತೆ ಇವಾಗಿರೋ ಕಾನೂನು ಪ್ರಕಾರ.
ಸರ್
ಹೇಳಿ.
ಸೂರ್ಯನಾರಾಯಣ ಸರ್ಗೆ ಸರ್, ಈಗ ಮಿತಾಕ್ಷರ ಸ್ಕೂಲ್ ಆಫ್ ಲಾ ಪ್ರಕಾರ ಜ್ಯೇಷ್ಠ ಪುತ್ರರಿಗೆ ಮೋರ್ ಶೇರ್ ಅಂತ ಹೇಳಿದಿರಲ್ಲ, ಆದ್ರೆ ಎಲ್ಲರಿಗೂ ಸಮಾನ ದೃಷ್ಟಿಯಿಂದ ನೋಡ್ಬೇಕಂತಕ್ಕಂಥದ್ದು ಒಂದು ಪ್ರಕೃತಿಯ ನಿಯಮ. ಇದ್ರ ಬಗ್ಗೆ ತಮ್ಮ ಅಭಿಪ್ರಾಯ ಏನಂತೀರಿ ಸರ್?
ಅಲ್ಲ, ಅದೇನಂದ್ರೆ ಈ ಜ್ಯೇಷ್ಠ ಪುತ್ರನಿಗೆ ಜ್ಯೇಷ್ಠ ಭಾಗ ಅಂತಕ್ಕಂಥದ್ದು ಈಗಿಲ್ಲ. ಅದು ಹಿಂದೆ ಶಾಸ್ತ್ರಿಕ್ ಹಿಂದೂ ಲಾಲಿ ಕೆಲವು ಏರಿಯಾಸ್ ಅಲ್ಲಿ ಮಾತ್ರ ದಟ್ ವಾಸ್ ಪ್ರಿವಲೆಂಟ್. ಅಂಡ್ ಜ್ಯೇಷ್ಠ ಭಾಗ ಅಂತಂದ್ರೆ ಅವ್ರಿಗೆ ಹೆಚ್ಚಿಗೆ ಇಷ್ಟೇ ಭಾಗ ಕೊಡ್ಬೇಕು, ಬೇರೆಯವ್ರಿಗಿನ್ನ 2 ಪಟ್ಟು ಭಾಗ ಕೊಡ್ಬೇಕು, ಆತರ ಏನು ಇರ್ಲಿಲ್ಲ. ಎಲ್ಲ ಹೇಗೆ ಅಂತಂದ್ರೆ, ಇವಾಗ ಒಂದು ಮನೆ ಇದೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಆ ಮನೆಯಲ್ಲಿ ಹಿರಿಯ ಪುತ್ರ ವಾಸವಾಗಿದ್ದಾನೆ. ಆ ಮನೆಯಲ್ಲಿ ಸಂಬಂಧಪಟ್ಟಂತೆ ಕೆಲವು ಶ್ರಾದ್ದಗಳು ಅದು ಇದು ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಅಥವಾ ಯಾರು ಕುಟುಂಬದಲ್ಲಿ ಅಕ್ಕ ತಂಗಿಯರೋ ಯಾರು ವಿಧವೆಯರಾದರೆ ಅವ್ರನ್ನ ನೋಡ್ಕೊಳ್ಬೇಕಾಗತ್ತೆ. ಈ ಎಲ್ಲ ನೋಡ್ತಕ್ಕಂತ ಡ್ಯೂಟಿ ದೊಡ್ಡ ಮಗನ ಮೇಲೆ ಇರ್ತಾ ಇತ್ತು. ಆದ್ರೆ ಆ ದೊಡ್ಡ ಮಗನಿಗೆ ಏನೋ ಒಂದ್ ಸ್ವಲ್ಪ ಹೆಚ್ಚಿಗೆ ಕೊಡ್ತಾ ಇದ್ರು ಅಷ್ಟೇ. ಅಂದ್ರೆ ಇಟ್ ವಾಸ್ ನಾಟ್ ಅನ್ ಅಕೌಂಟ್ ಆಫ್ ರೈಟ್. ಇದೆಲ್ಲ ಏನು ಅಂದ್ರೆ ಬೈ ಕನ್ಸೆಂಟ್. If the father is there, he would say, give the son a little higher share. And ilde idre, the brothers would say, you take a little higher share. You are the person who got to have the responsibilities. In fact, sir, joint family system ಅಲ್ಲಿ ಏನ್ ಸಂತೋಷ ಇದೆ ಅಂತ ನಾನು 35 ವರ್ಷ ಅನುಭವಿಸಿದ್ದೀನಿ ಸರ್. ನಾನು 35 ವರ್ಷ I lived in a joint family with 23 other people at home. It was so, I have enjoyed my life in the joint family. My uncle, much more than my father, my uncle was so close to me. Sir, you see, you can't get back those days.
Yes.
Very unfortunate. We don't find such families at all nowadays.
ಅದಕ್ಕೆ ಹೇಳೋ ಸರ್, ಜ್ಯೇಷ್ಠ ಪುತ್ರ ಪಿತೃ ಸಮಃ. ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ.
Like it is not a right, it's always a responsibility. Everybody thought what I can contribute to the family. The question is not what I can get from the family. This was the approach. Therefore, everybody was happy.
And it is not a matter of right. It is
Not a matter of it.
right.
ಸರ್, ಧನ್ಯವಾದಗಳು. ನಾವು
ನಮಸ್ಕಾರ.
ಮತ್ತೆ ಅವಕಾಶ ಬರ್ತದಕ್ಕೆ ನಮಸ್ಕಾರಗಳು. ಮತ್ತೆ ಬರ್ತಾ ಇರಿ. ಒಂದ್ಸಲ ಕಲಬುರಗಿಗೆ ಬನ್ನಿ, ಮರ್ತೂರು ನೋಡ್ಲಿಕ್ಕೂ ಬನ್ನಿ ಅಂತ ತಮ್ಮೆಲ್ಲ ಇಲ್ಲಿರ್ತಕ್ಕಂಥ ಎಲ್ಲರಿಗೂ ಆಮಂತ್ರಣ ಕೊಡ್ತೇನೆ. ಯಾಕಂದ್ರೆ ಸನ್ಮಾನ್ಯ ಗೌರವಾನ್ವಿತ ಮುಖ್ಯ ನ್ಯಾಯಾಧೀಶರು ಕಲಬುರಗಿಗೆ ಬಂದಾಗ, ಮರ್ತೂರು ಭೇಟಿ ನೀಡಿದಾಗ ಐ ಫೈಂಡ್ ವೈಬ್ರೇಷನ್ ಅಂತ ಹೇಳಿದ್ರು. ಅಷ್ಟೇ ಅಲ್ಲ, ಅವರು ವಿಲೇಜ್ ಹೆಸರು ಕೇಳಿದ್ರು. ಮರ್ತೂರು ಅಂತ ಹೇಳಿದಾಗ ವಾಟ್ ಇಸ್ ದ ಮೀನಿಂಗ್ ಅಂತ ಕೇಳಿದಾಗ ಮರೆತು ಹೋದ ಊರು ಅಂತ ಹೇಳಿ ಫಾರ್ಗಾಟನ್ ವಿಲೇಜ್ ಹೇಳಿದ್ವಿ. ಅವ್ರು ಹೇಳಿದ್ರು ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಫಾರ್ಗಾಟನ್ ವಿಲೇಜ್, ಇಟ್ ಇಸ್ ಎವರ್ ರಿಮೆಂಬರಿಂಗ್ ವಿಲೇಜ್ ಅಂತಕ್ಕಂಥ ಮಾತನ್ನ ಹೇಳಿದ್ರು. ಅಷ್ಟೇ ಅಲ್ಲ, ಸಾಮಾನ್ಯರಿಗೆ ಕಾಶಿ ಇದ್ದಾಗೆ ಲಾ ಓದಿದವರಿಗೆಲ್ಲ, ಲಾ ಪುಸ್ತಕ ಮುಟ್ಟಿದವರಿಗೂ ಕೂಡ ಇದು ಕಾಶಿ, ಎಲ್ಲರೂ ಬರಬೇಕು. ಇಟ್ ಈಸ್ ಬಿಕಾಸ್ ಆಫ್ ಹಿಮ್ ವಿ ಆರ್ ಅರ್ನಿಂಗ್ ಬೆಡ್ ಅಂಡ್ ಬಟರ್ ಅಂತಕ್ಕಂಥ ಮಾತನ್ನ ಸನ್ಮಾನ್ಯ ಲಾಹೋಟಿ ಅವರು ಉದ್ಘಾಟನೆ ಮಾಡಿದ್ರು. ಸಾದೃಷ್ಟಿದ ತಾವೆಲ್ಲರೂ ತಮ್ಮ ಸಹಕಾರಿಗಳೊಡನೆ ಒಂದ್ಸಲ ಆದ್ರೂ ಲೈಫ್ ಟೈಮ್ ಅಲ್ಲಿ ಕಾಶಿಗೆ ಜನ ಹೆಂಗ್ ಹೋಗ್ತಾರೆ, ನೀವು ಬನ್ನಿ, ನೋಡಿ, ನಮಗೆ ಸಹಕಾರ ಕೊಡಿ, ನಾವು ಒಟ್ಟಿಗೆ ಮುಂದುವರೋಣ. ಟುಗೆದರ್ ವಿ ಕ್ಯಾನ್. ಧನ್ಯವಾದಗಳು.
ಮಿಥಾ ಅಕ್ಷರ ಅಂದ್ರೆ ಇನ್ನ ಒಂದು ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಕೊಡ್ಬೋದು. ಮಿಥಾ, in very little words the law is expressed. So Mitha Akshara, and in thick way it is in very concise terms that law is expressed. Maybe that's the reason why the law is given the name Mithakshara. That's one possible interpretation. That's also possible.
ಸರ್, ಅದಕ್ಕೆ ಇದು ಸೂತ್ರ ಭಾಷೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅದಕ್ಕೆ.
ಸೂತ್ರ ಭಾಷೆ, ರೈಟ್.
ಅಲ್ಪಾಕ್ಷರಂ ಅಸಂದಿಗ್ಧಂ, ಅಲ್ಪಾಕ್ಷರಗಳಲ್ಲಿ ಅಲ್ಪಾಕ್ಷರಂ ಅಸಂದಿಗ್ಧಂ ಸಾರವತ್ ವಿಶ್ವತೋಮುಖಂ. ಅದ್ರ ಸಾರ ವಿಶ್ವತೋಮುಖ. ಸೂತ್ರಂ ಅಂತ ಹೇಳ್ತಾರೆ. ಸೂತ್ರದ ತರ ಹೇಳಿ.
ಧನ್ಯವಾದಗಳು ಸರ್. ಎಲ್ಲ ಸನ್ಮಾನ್ಯ ಗೌರವಾನ್ವಿತರಿಗೆ ಮತ್ತೊಮ್ಮೆ ಧನ್ಯವಾದಗಳು. ಮತ್ತೊಮ್ಮೆ 3ನೇ ತಾರೀಕು ನಾವು ನಿಮ್ಮನ್ನೆಲ್ಲ ಎದುರು ನೋಡ್ತಾ ಇದ್ದೇವೆ. ಅವತ್ತೊಂದು ದಿನ ಮತ್ತೊಂದು ವಿಷಯಕ್ಕೆ ಲೆಕ್ಚರ್ಸ್ ಜೊತೆ, ಉಪನ್ಯಾಸ ಜೊತೆ ನಾವು ನಿಮ್ಮೊಟ್ಟಿಗೆ ಬರ್ತೇವೆ. ಧನ್ಯವಾದ.